Today, I will be discussing some of the basic concepts of arbitration and in particular as to how they are different from litigation, and then discuss as to how that has made a difference during the pandemic insofar as arbitration is concerned. So starting with the very basic concepts, first question is, what is the most fundamental principle of arbitration that we find insofar as the legal concept is concerned? So in a sense, what distinguishes arbitration from other areas of law? That is the feature of party autonomy, which means that the parties can choose as to how they want the proceedings to be conducted. The parties can choose the procedure, they can define the format for arbitration, they can choose who the arbitrator should be, and they can choose where the review for the arbitral award should lie in after the award has been rendered. So in short, it is the parties who determine the course of the entire proceedings, and that forms the very core of arbitration, which is distinct from litigation. Because if one goes to a civil court, then as far as the procedure is concerned, then the parties have to be bound by the CPC. As far as the judge is concerned, the parties have to follow the norms of territorial jurisdiction, pecuniary jurisdiction, subject matter jurisdiction, and go to that court. And obviously, they do not have a choice in choosing who the judge will be. They do not have a choice as to where the proceedings can lie, and those factors are limited. But in arbitration, they have quite a degree of freedom as far as those aspects are concerned. But an important rider that I would like to place here is the element of public policy, which means that the fact that parties have autonomy does not mean that they can choose absolutely anything that they want, and that the principles of public policy curtail the parties' freedom to choose the procedure and the manner of arbitration. So just to take an example, can the parties choose that the arbitrator who's going to decide the matter, the dispute between the two parties, will be the partner of one of the law firms which is representing a party to the arbitration? The answer would be no, because obviously if a firm is representing one of the parties to the arbitration, then the partner of that law firm will be interested in the dispute, and therefore he cannot be an arbitrator in those proceedings. So that is the element of public policy, which is in this case the element of independence and impartiality of arbitrators, which limits the parties' rights to determine the course of the arbitral proceedings. So the general rule is that parties can choose as in what they want, and the exception to that is the element of public policy. So when we look at the Arbitration and Conciliation Act, we find this feature of public policy in several provisions. As I said, one is the issue of appointment of arbitrators, section 11 and 12 you will find. And then you will find once the arbitral award has been rendered, in those cases also the award is subject to public policy grounds. So that's the very basic feature of arbitration. Now, if we take the important features and start from the Arbitration and Conciliation Act, what is it required for parties to go to arbitration? In what situations can they choose not to go to court and go to arbitration instead? So there are two ways of doing that. Or rather, the basic element is that there has to be an arbitration agreement, which means that both parties have to agree to go to arbitration. And that agreement can be arrived at two stages. First is before any dispute has arisen, which is more common. In situations where parties enter into any contractual bargain, the contract can of course contain an arbitration clause. And therefore, in such a situation, when the dispute arises, the parties cannot go to the civil court and they will have to resolve their disputes to arbitration. The second situation is where after a dispute has arisen, even in those situations, assuming there is no pre-existing arbitration clause, the parties can decide and agree that, okay, we will not go to a civil court and instead we will choose to go to arbitration. So these are the two stages in which the parties can agree to refer their disputes to arbitration and not go to a civil court. But a very important feature of an arbitration agreement is that it has to be in writing. So as you all know, contracts do not necessarily have to be in writing, and they can be orally performed, executed and performed as well. But insofar as an arbitration agreement is concerned, even though it is a contract, it is necessarily to be in writing. Now, does anyone have any guess as to why this requirement is there for an arbitration agreement to be in writing? Anyone from the audience has any guesses?
I think the reason that both parties would have to have a written contract in arbitration is that they've both chosen the judge, and then the principle of estoppel would apply if they want to go back on it.
Okay, that is a good point, that the written requirement forms an evidence of the fact that parties have chosen to go to arbitration and not to court. But there is one more reason, which is also a fundamental reason as to why it has to be in writing. Any other answers?
If the dispute goes to court, it may act as an evidence in the court of law if it is in writing.
Correct, absolutely. So the arbitration agreement is, if it's in writing, then there's evidence of the fact that the parties agreed to go to arbitration. But another reason is that each individual, each person has an inherent right to go to a civil court to file a case. And contractually, you cannot take away someone's right to go to the civil court. So an arbitration agreement is essentially doing that. It is taking away an individual's right to go to court. And therefore, the law requires that if you are curtailing that right in certain situations, in case of an arbitration agreement, let's say, that right has to be curtailed specifically, and there cannot be any ambiguity about it. Therefore, an arbitration agreement has to be in writing, and any oral arbitration agreement will not suffice. So you will find this in Section 7 of the Arbitration and Conciliation Act. So when they say in writing, what does it mean? Does it mean that in every situation, both the parties have to execute a contract and formally sign the contract, and only then an arbitration agreement will come into existence? The answer is no. Even if Section 7 itself says that even if, let's say, there is an exchange of correspondence between the parties in the form of letters or emails, and that correspondence includes an arbitration agreement, that can also form a valid arbitration agreement for parties to go to arbitration. So it is not that the two parties have to necessarily sign a document and execute that contract for it to constitute a valid arbitration agreement. Now, that said, I must point out that in some countries, an oral arbitration agreement is also recognized. So France is a classic example of this, where the French law on arbitration recognizes an oral agreement to arbitrate. The reason, well, is typically that the French are a bit of an exception when it comes to the traditional norms of arbitration. And this is just one of the many features in which their arbitration law is slightly in deviance as far as the deviance from the other countries on arbitration law are concerned. So that is on the issue of how to form an arbitration agreement and refer your matter to arbitration. The other important element is who can be an arbitrator? How do parties appoint an arbitrator? Can the parties provide for it in the agreement? Or does the arbitrator have to be appointed by court? Or is there a third party, an institution which appoints an arbitrator? The answer is that all these avenues are open. The first situation, of course, is that if parties agree to an arbitrator, then that person will be the arbitrator. The parties can choose to have one arbitrator, they can choose to have 3 arbitrators, or they can choose to have 5 arbitrators or more. As far as they are in odd numbers, there can't be an even number of arbitrators. This is expressly provided in Section 10 of the Arbitration Act. But let's say a situation arises where the parties don't agree to a common arbitrator, or in case of 3 arbitrators, they don't agree to the president's appointment. Then what happens? This situation is more often than not, and then the parties have to go to the court for appointment of arbitrator. So the question is, which court do they have to go to? Is it the civil court, the civil court of the lowest pecuniary jurisdiction? Is it the district court? Is it the high court or the Supreme Court? So Section 11 gives you the answer. As per Section 11, in all cases of domestic arbitration, the parties have to go to the high court for the appointment of arbitrator. And in case of an international arbitration, the parties have to go to the Supreme Court. Now, what is an international commercial arbitration? You will find it's defined in Section 21F, And the requirement is that at least one of the parties should not be Indian. There is more nuance to it, of course, but right now I'm not going into it due to time constraints. But as long as at least one party is not Indian, it constitutes an international commercial arbitration. So in a situation where one party is Indian and the other party is from, let's say, Singapore, or let's say both parties are from Singapore or England, or one party is from England or Singapore. In all those cases, it is an international commercial arbitration. And for appointment of arbitrator, the parties have to go to the Supreme Court under Section 11. So that is insofar as the manner of appointment is concerned. The next question is, who can be an arbitrator? Is it only advocates who can be arbitrators, or is it only retired judges who can be arbitrators? Any response on that? Can a chartered accountant be an arbitrator?
I think it can be anyone, not necessarily it should be a CA or something.
That's right. So it's not that only an advocate can be an arbitrator, or that only a retired judge can be an arbitrator. It can be any individual. And especially you will find in a lot of construction contracts that they involve at least one of the three arbitrators. Typically, they have three arbitrators involving large construction matters. One of them you will often find is an engineer. And the reason for that is that they have the technical knowledge and they have expertise in that. So they can guide the arbitral tribunal on the technical aspects of the matter, which is why parties may want to choose an expert in that field to be one of the three arbitrators. It is usually rare to find a non-advocate or a non-retired judge as the sole arbitrator. And in most situations, you will find that it's advocates or judges who are acting as arbitrators. And in high stakes matters where it's the High Court or the Supreme Court who's appointing the arbitrator, more often than not in India, you will find that it's retired judges who are appointed as arbitrators. If you see internationally, then this trend is not there. There you have most people who are not retired judges, and they are experts in the field of international arbitration. They can be law firm partners, or they can be full-time arbitrators, and so or they can be professors of arbitration law, and in investment arbitration they can be professors of international law. So that is very common outside India. But in India, we are still, at least currently, following this trend of appointing retired judges as international arbitration in high stakes matters. And well, there is obviously some degree of justification also, because they bring in that element of procedural regularity and the fact that they have disposed of cases for 2 decades or 3 decades and heard parties in that sense. That is the justification which is provided for appointing them. But there's no reason why experienced lawyers or experienced experts in a given field can be arbitrators as well. And so that's the first aspect. The second aspect is how to regulate the independence and impartiality of arbitrators. Does the Arbitration and Conciliation Act provide for it? Or is it based on a case-to-case basis? So we find that prior to the 2015 amendment to the Arbitration and Conciliation Act, although the requirement of independence and impartiality was always present, there were no specific guidelines as to who could have been appointed as an arbitrator from the perspective of independence of the arbitrator. So there were often situations where, especially in let's say railway contracts or other public sector agreements, you would find that one of the employees of that public sector organization would be nominated or appointed as the arbitrator. So those kind of situations were found to be problematic, and therefore the 2015 amendment brought in a detailed set of guidelines on the independence and impartiality of arbitrators. So these were borrowed from the IBA guidelines, which has 3 lists, the red list, the green list, and the orange list. So these lists govern different fact situations and different degrees of independence and impartiality of arbitrators. So people who are in the red list cannot be appointed as arbitrators. And these would be very obvious situations where a person is very likely to be biased in one way or the other, subconsciously, even if not consciously. So let's say if my law firm colleague is being appointed as the arbitrator. Then that sort of a situation is not permissible. The orange list has situations in between, and the green list has situations where there is no restriction on the appointment of such individuals as arbitrator. So that is briefly the rule governing the independence and impartiality of arbitrators, which we now find in section 12 of the Arbitration Act. So once the tribunal has been constituted, then the proceedings start. The rules for proceedings, as I said, the CPC does not necessarily apply. The Act specifically says that the CPC shall not apply. But typically in domestic arbitrations, you will find that the procedure which is followed is largely akin to what is provided in the CPC, although it's not strictly applied in the context of arbitration. But the difference between the domestic arbitration and international arbitration is that there in the latter, you will not find that the CPC is strictly followed. And in fact, over a period of time, the norms of procedure in international arbitration have themselves acquired a sort of a customary practice. So just to give you an example, in international arbitrations, you will find what is called a Redfern schedule, which is basically the stage of production of documents. So both parties have the opportunity to ask the other party to produce documents on any given issue which the party wants, and they can submit the request for documents to the other party. The other party has a chance to respond, and then there's a rejoinder, and then the tribunal decides when there's a dispute on that. So that is called a Redfern schedule, and this is now becoming this has become very common in international arbitrations. But this practice is not there in domestic arbitrations, because there you will find that even though CPC technically does not apply, the provisions of or the rules of CPC are generally followed as a guideline for domestic arbitration. So once this procedure is followed and the award is passed, then the question arises that what is the remedy available against the arbitral award? A fundamental difference between a civil court judgment and an arbitral award is the remedy available against the two. So in case of a civil court judgment, you can go in appeal against the judgment before the appellate court, which is called a regular first appeal. In case of an arbitral award, you have to file what is called setting aside proceedings under section 34 of the Act. The difference between the two is that when you go in an appeal against a judgment, then you can ask the appellate court to review every single issue which was raised before the civil court at the first instance. That is something which is not allowed when you challenge an arbitral award. When you challenge an arbitral award, the grounds on which you can challenge the award are very limited. And the grounds are mostly related to the procedure of arbitration. So the manner in which the proceedings were conducted, and not the merits of the dispute. So to illustrate with the help of an example, let us say that the parties said that person X will be appointed as the arbitrator, but the arbitrator eventually appointed was not Mr. X but Ms. Y. In that case, because the arbitral tribunal has not been formed in accordance with the agreement of the parties, that can be a ground to set aside the award. But let's say that the arbitrator finds on a given issue, let's say that if one of the parties was supposed to sell 50 tons of cotton to the other party, and the arbitrator finds that the cotton was sold, but there was some defect in the cotton based on evidence. When you file a challenge against the award under 34, that finding of whether or not there was a defect in the goods supplied cannot be challenged in the 34 proceedings unless the arbitrator's finding is patently illegal or it's based on no evidence. So in short, the recourse which is available on the substance of the dispute or on the merits of the dispute is very, very limited, very, very narrow in an arbitral award challenge, as opposed to a challenge to a civil court judgment. So what is the reason for this? Why is it that the law says that when you challenge a civil court judgment, you can challenge practically everything, whereas when you challenge an arbitral award, you cannot challenge on the issue of merits, and you can challenge only on the principles of, on the grounds of procedure. The reason is that the law assumes that when two parties have agreed that person X or person Y or three people will decide their dispute, they fully submit to their decision as far as the merits of the dispute is concerned. And therefore, the merits then cannot be reviewed by a court. What the court can review is only the procedure. And by procedure, I also mean here what I had mentioned right at the beginning, which is public policy. So public policy is a ground for challenge to every arbitral award. And this is not just in India, but this is across jurisdictions. So for instance, let's take an example where two parties say that, or two parties decide to refer the dispute, a criminal matter, to arbitration proceedings. So X is accused of murdering Y, and then Y's family and X decide to refer the dispute to arbitration. The dispute of the trial of X for the murder of Y. Arbitral award is rendered. In that case, can the award be challenged? Because I had mentioned earlier that the foundation of arbitration is party autonomy. So in exercise of party autonomy, can two parties refer a criminal dispute to arbitration? The answer is no, because of the limitation imposed by public policy. And therefore, under section 34 as well, public policy is a ground to challenge every arbitral award. And since in this case, a criminal matter has been referred to arbitration, which is not permissible in law, the award is bound to be set aside. So why is it that certain matters then cannot be referred to arbitration? I've taken the example of criminal matters, but the law recognizes certain other situations as well, which cannot be referred to arbitration. So for instance, matrimonial dispute cannot be referred to arbitration, or disputes relating to the legality of a patent cannot be referred to arbitration, or disputes relating to trust law cannot be referred to arbitration. So why is it that these disputes cannot be referred to arbitration, but as a dispute between A and B, where A had to sell 50 tons of cotton, and on a dispute on that can be referred to arbitration? Any responses on that? Why is it that some disputes can be referred to arbitration and not the others?
I think because it involves a larger public. So, in these cases, a large amount of public might get affected.
Exactly. Because these disputes involve again an element of public policy. It is the larger public interest which is involved in getting these disputes resolved to an open through an open forum, through a public forum. Because a court is open to all, but arbitral proceedings are private in that sense. If A and B are arbitrating their dispute, then third parties would not even know that this arbitration is going on until and unless the award is rendered and the award is challenged in the court of in a court under section 34. So because in disputes involving elements of public interest, which is criminal matters and the other matters which I mentioned, those disputes require a public trial and an open forum to adjudicate upon them. And therefore, they cannot be decided by a private forum. For that reason, certain categories of disputes are excluded from the scope of arbitration. So this is called arbitrability. And the law says that if an award is passed on an issue which is not arbitrable, then that award cannot be sustained under section 34(2)(b) of the Act. So arbitrability, in short, is just a subset of public policy. It's one of the elements of public policy. Arbitrability kicks in before the dispute even arises, in the sense that everyone knows what the subject matter is, and therefore it should not be referred to arbitration at all. And the other elements of public policy, they operate during the arbitral process and once the award is passed. So those are some of the grounds which you will find for challenging an award under section 34. And as I said, the fundamental distinction between a 34 challenge and an appeal against a judgment of a civil court is the grounds for review, the grounds for challenge of the award versus the grounds for challenge versus the judgment. And this, in a way, also ensures the efficacy or the expeditious nature of arbitral proceedings, and the fact that the proceedings are concluded right from the beginning, from the onset of the dispute till the decision of the Supreme Court in a swift manner. Because naturally, if the grounds for challenge under 34 are limited, then deciding those challenges is also going to take lesser time. And therefore, a 34 proceeding will be disposed of faster as opposed to a regular first appeal against a civil court judgment. Similarly, once that goes into appeal, you can file an appeal against an order of a section in a section 34 petition under section 37. And then one can go to the Supreme Court if the SLP is admitted. So the entire proceedings can be disposed of in a faster manner when it comes to challenge against arbitral awards, as opposed to challenge to a civil court judgment. And that adds to the what is called the efficacy of the arbitral process. So this is insofar as the challenge procedure is concerned. Now, once the award is passed, the execution has to be done by the civil court, as in the case of a civil court's judgment. There is no difference in the execution process. Execution has to happen under Order 21 of the CPC in both the situations. So that is for the purposes of execution. There is a slight distinction when it comes to a foreign award. A foreign award is an award which is rendered in an arbitration where the seat is outside India. When I say seat, I mean seat is a unique feature of arbitration, which you will not find in the other situations. The seat of arbitration means the location which will govern first of all, the applicable law to the arbitration. Secondly, the courts which will have jurisdiction over the arbitral process. And that includes the process of appointment of arbitrators and then the challenge process once the award is passed. So that is what is determined by the seat of arbitration. Now, a unique feature of the seat of arbitration is that, let's say a party is sitting in Bombay and another party is sitting in Delhi. Typically, if you look at rules of a territorial jurisdiction under CPC, the matter can only be referred to where the defendant resides or where the cause of action is arisen. So it can be Delhi or Bombay, or it can be the place where the cause of action arises. Let's say the cause of action arises in Gujarat. So it can be the court in Gujarat. But in arbitration, what can be done is that a party sitting in Bombay and Delhi can say that, look, I want the courts of Bangalore to have jurisdiction over my dispute for XYZ reasons. So they can say in the agreement that the seat of arbitration will be Bangalore. If they choose to do that, then every court matter relating to that arbitration has to go to Bangalore. So if the parties want an arbitrator to be appointed, then it will go to the High Court of Karnataka in Bangalore. Once the award is rendered, it will be the civil court in Bangalore, which will have jurisdiction. So that is the importance of seat of arbitration. Now, I was talking about foreign award. Foreign award is an award where the seat of arbitration is outside India. And all those situations are governed by Part 2 of the Arbitration Act. And in those situations, any party that wants to enforce that award has to come to the Indian court and seek enforcement under Part 2 of the Arbitration and Conciliation Act. So for the purposes of execution in such cases, the party which wants to enforce the foreign award has to apply for enforcement. The losing party can then challenge or resist enforcement on certain grounds, which are similar to the grounds under Section 34. And in some aspects, they are narrower. So assuming those grounds for challenge are rejected, then the execution will be carried out as per the CPC. So this, in short, is the procedure for enforcement of a foreign award, which is under Part 2. Part 1 deals exclusively with arbitrations where the seat of arbitration is in India. Now, naturally, the flexibility which is associated with arbitration has meant that during the pandemic, when courts have been shut for most part of the year, insofar as your regular matters are concerned, arbitrators have continued to happen on virtual platforms, and including things like cross-examination are also happening on the virtual platform. And final hearings, of course, can happen on the virtual platform. So in that sense, as compared to court litigation, they have offered a faster mechanism for disposal of the cases during the pandemic. Now, this virtual platform has been in place in international arbitrations even before the pandemic. So especially because of the challenges associated with the different locations of various parties and the council representing the parties in international arbitration. So one party's council may be in Bombay, the other's parties may be in London, the other third party's council may be in Singapore. So in those situations, even before the pandemic, some hearings used to happen virtually, especially interim hearings. And the hearings for setting up the for determining the timetable of the arbitration and smaller matters were often done through a virtual platform. But this, because of the pandemic, has now been adopted in domestic arbitration also, which is a very, very good thing which has happened, because it can continue even after all of this gets over and we come out of it. Because it definitely ensures that things move in a faster way, and that for smaller procedural hearings, at least, parties don't necessarily have to assemble physically in a common location. And that can save a lot of, first of all, travel time and the cost of litigation which the parties have to bear. So that's in short how the proceedings have gone on during the pandemic. Now, I wanted to discuss some distinctions between international arbitration and domestic arbitration. So there are two classes of differences which you will find. One is the legal differences, and the second is practical. So let's talk about the legal differences first. The most important difference under Indian law is that once an award has been rendered, in the context of international arbitration, the scope of review is narrower as compared to the scope of review in case of a domestic arbitration award. And this you will find in section 34(2)(a). Section 34(2)(a) of the award has a specific ground for challenge in case of a domestic award, which is the ground of patent illegality. This ground is not available in case of an international arbitration. So till the 2015 amendment to the Arbitration Act, patent illegality was a ground for all awards, whether they were rendered in the context of international arbitration or whether they were rendered in the context of domestic arbitration. But after the amendment, this ground of patent illegality is available only in case of a domestic arbitration. And this significantly narrows the scope of review of awards in case of an international arbitration, because the tribunal then in such circumstances cannot set aside an award on the ground of patent illegality in case of international arbitration. Now here I must point out an important thing, which is what do I mean by international arbitration in this context under section 34. International arbitration, as I had mentioned earlier, is where at least one of the parties is not Indian. So when I'm talking about a challenge under 34 to an international arbitration award, it means an award which is rendered where at least one of the parties is not Indian and where the seat of arbitration is in India. If the seat is outside India, then it becomes a foreign award. And that award cannot be challenged under 34. That award cannot be set aside by an Indian court. Because the fundamental rule of arbitration is that an award can only be set aside by the court at the seat of arbitration and not otherwise. So coming back to the legal difference between an international arbitration and a domestic arbitration. First, as I said, is the scope of review of an arbitral award. Another distinction, as I had mentioned earlier, is in the procedure for appointment of arbitrators. For a domestic arbitration, you have to go to the High Court, whereas for an international arbitration, you have to go to the Supreme Court. Thirdly, the procedure for international arbitration is not necessarily based on CPC. Whereas in a domestic arbitration, even though the CPC does not apply to arbitrations, you will find that most of the timetable which is prepared is in accordance with the procedure which is prescribed in the CPC. And even for the interim aspects during the arbitration, arbitrators are guided by the principles of CPC, which is not the case necessarily in international arbitration. So these are some of the legal differences in international arbitration and domestic arbitration. Now, what are the practical differences? The practical differences we will find are in things such as the manner in which pleadings are drafted. So in a domestic arbitration, the pleadings are drafted in the same format as your civil court litigation. But that is completely different when you do an international arbitration matter, because there the pleadings have to be very, very detailed. And in most cases, each of your arguments which you want to raise has to be mentioned in the pleadings. So what we do in the civil litigation context, that you can mention the pleading, but you can cite judgments later, or you can raise any legal issue later. That practice is followed in domestic arbitration. But that is not necessarily the case in international arbitration. And in most instances, you will find that that international arbitral tribunals require all aspects of the matter, including fact and law, to be submitted in the written form before the hearing commences, which is not the case in a domestic arbitration. So you will have to cite all your judgments in advance and give a copy of the judgments in advance to the other party and to the arbitrator in an international arbitration. But in a domestic arbitration hearing, you can cite the judgments on the spot and serve a copy to the other side at that time itself. So in that sense, the level of preparation which is required before the hearing is more extensive in international arbitration as compared to a domestic arbitration, where most of the work is done in terms of the final hearing. It's done at the time of hearing and not necessarily at the time of pleadings. So pleadings assume more importance in international arbitration as compared to domestic arbitrations. So these are some of the practical differences between the two. Now, you must have also come across in international arbitration, there is a specific category of arbitration, which is international investment arbitration, which is basically a dispute between an investor and a country, a foreign state. So an investor decides to go and invest in another country, and there's a dispute between the investor and that country. So that dispute can be referred to an international arbitral tribunal in what is called an investment arbitration. So this typically arises under treaties. It can be either a bilateral treaty or it can be a multilateral treaty. So some of the classic examples of multilateral treaties are your Energy Charter Treaty, which has most of the European states as parties. Then you have the NAFTA, which was there earlier between the US, Mexico, and Canada. And then there are some free trade agreements between different countries. So under those treaties, this investment arbitration has now become popular and prevalent in the last 3 decades. Before that, it was practically non-existent. So this is one separate branch of international arbitration which has come. So that's a brief summary of the basic concepts which I wanted to discuss.
My query is that as far as the law of limitations is concerned for appeals and arbitration, I recently read that there was a judgment that some particular order passed in arbitration proceedings cannot be appealed after 90 days. Can you please shed light on that?
Yes, so once an award is passed, then there is a 90-day period to challenge the award, and then there's a 30-day discretionary time period. Above that, beyond that 90-day period. So in short, it's 3 months really, not 90 days. 3 months plus 30 days to file the challenge against the arbitral award. And you cannot file beyond that. If you cross that time limit, then your challenge proceedings will be dismissed and the award will be final.
I wanted to ask that, can it be an international arbitration if only the seat is outside India and the parties are Indian?
If both the parties are Indian and the seat is yes. So in fact, there's a recent judgment of the Supreme Court. Yes, Justice Nariman's judgment is there on this issue, which is recently decided as to whether 2 Indian parties can have a foreign seat. And the Supreme Court held that it can. And that will also be an international commercial arbitration.
Okay, so they will follow all the rules that go under international arbitration.
Yes. So when you say rules under international arbitration, there are no uniform rules for international arbitration as such. It all depends on where the seat of arbitration is. And if the parties choose to have their dispute resolved through an institution, then the rules of that institution. So if the Indian parties in your example say want the seat to be London, then the English Arbitration Act will apply to the proceedings. And if on top of that, if the parties want it to be an ICC arbitration, then the rules of the International Chamber of Commerce for arbitration will apply to the proceedings.
Okay. And one more question.
Yes.
How much does a court, Indian court, interfere in an international arbitration. Suppose if I'm saying these parties are going to through an international arbitration, but something has come up and they want to go to the civil courts, how much interference is allowed, or what is the uh, participation of Indian courts in such matters?
It depends on what the nature of the the intervention required is. So see, the basic rule under the Arbitration Act, under Section 5, is that the court will not interfere unless the Act provides for it. So unless the Act gives the parties a recourse to approach a court, the court cannot interfere in an arbitration proceeding, whether it be international or domestic. So if you're talking about
All right.
about interference at this stage of arbitral award, then as I said, the ground for review of an award in case of an international arbitration is narrower as compared to a domestic arbitration.
See, we have one party which is Indian, another party which is a foreign, who both have engaged. Just I'm giving an example, hypothetical, that party A is an Indian, party B is an international party, and they have done an arbitration in Singapore. The seat of arbitration was in Singapore. Now the clause has been settled, everything, and now the deal falls through. A sells something to C. Okay. And now B invokes its arbitration clause just to frustrate A, that the sale should not happen to A to C. Now, in that case, how to enforce this? That basically we had agreed to something between A and B, was something agreed at Singapore, at their seat of arbitration in Singapore, as per the Singapore laws. Now, but what has happened is that the sale of the asset, which is in India, has done from from A to C, another party. And now B is invoking its arbitration clauses that no, this is not legal, and we have a say in it, and we want to stay. And they move to Supreme Court. So this is what basically is in that case. This is a hypothetical case. So the party which is A, how can it protect itself? Also, party B how can it invoke its clauses that have been agreed by both party A and B when they were, first of all, they agreed to that in Singapore. So how to go about this basically?
If B wants to invoke arbitration and stop A from selling the goods to C, then B can come to an Indian court and file proceedings under Section 9 of the Act. Or B can invoke arbitration and ask for an interim order by the arbitral tribunal to restrain A from selling the goods to C. So both those remedies are available, and the nuances, of course, depend on the detailed fact situations.
Oh, but sir, that is what I'm saying. This is where any party which can start playing a mischievous game and frustrate another party. That is, first the A and B, any one of them can do this and actually act mischievously to frustrate the other party. That is reneging on their agreement basically. So
there is no question of frustrating, because the courts enforce an arbitration agreement. So if B wants to seek any relief against A, then it can invoke arbitration and get the remedy. And if A wants to frustrate B by selling the goods to C, then B always has the recourse to the Indian courts for interim reliefs under Section 9, or to the Singapore, the arbitral tribunal to be constituted in Singapore.
So just to digress, why I ask this question is because if you are following current news, if you see something similar is happening right now in India with a Future Group and Reliance and with Amazon, as we are seeing that they are invoking that another agreements and what they have agreed. So this is where if you can possibly explain a bit about that situation, that would be great if allowed and if possible. That's what I'm saying.
That situation, see, as per my understanding from news reports, is that Amazon wants to restrain Future Group from selling its shares, but it seems that they have an arbitration agreement providing for arbitration in Singapore. So they have invoked that remedy and they are exercising their contractual right. That's it. There is no question of one party frustrating the other party's rights. It's all a question of contract. Whatever right Amazon has under the contract against Future Group, it's entitled to enforce that, and that's what it is doing.
Okay, so in that case, they can move to Supreme Court. That is, any two parties that are there involved, they can move to, because
they cannot. They have not gone directly to the Supreme Court. They have gone right since initially they invoked arbitration. And the emergency arbitrator passed an order, and then they went to the Delhi High Court. From Delhi High Court, single judge, they went to division bench. Then they went to the Supreme Court.
Thank you for the answer, sir.
Sir, can we revoke an arbitration agreement?
Unilaterally, no. You can revoke
Okay,
it.
so
Yeah, both parties can choose to revoke it together by consensus, but not unilaterally.
can it be at any step of the arbitration proceedings?
Yes, of
Like
course.
whatever it, okay.
Yes.
So one more question.
Yes.
If two parties are foreign, can
Hmm.
they have an arbitration proceeding, like the seat of arbitration in India?
Yes.
So will that be a foreign award or a domestic proceeding?
Domestic award.
Okay, that will be a domestic award.
Correct.
Okay, so accordingly, CPC and the High Court rules, like you mentioned earlier, will apply.
No, no, CPC will not apply. It
No,
will
I'm sorry. They can like they have a remedy in the High Court because it's a domestic, like you said, it's
they have a remedy in the High Court. They have a no. It's an international arbitration, but the award is a domestic award. So they are two different concepts. One is
uh,
what is a domestic award and what is a foreign award. A
okay. So this
domestic
is a
award is
domestic award, but an international arbitration proceeding.
correct. A domestic award is an award where the seat is in India, and a foreign award is an award where the seat is outside India. So this is the distinction between a domestic award and a foreign award. The second set of concepts is what is a domestic arbitration. It's not defined anywhere in the Act, but let's take it for now. Domestic arbitration versus an international commercial arbitration. A domestic arbitration is where both parties are Indian, and an international commercial arbitration is where at least one party is foreign. So if both parties are foreign, then that is also an international commercial arbitration.
I want to know, can you highlight the career prospects in arbitration with the current pandemic? So, like many are law students, so for them, can you give some guidance?
Yeah, sure. So, see, arbitration has become an extremely popular area of law now, and more people are going into this. And it's also obviously increasing because more and more parties are executing arbitration agreements and choosing to go to arbitration and not to the civil court. So, there is always going to be a demand for people who are, uh, people who have knowledge of this area of law. And now what is also increasing a lot is the participation of Indian lawyers in international arbitrations. Earlier, you will find that there were very few Indian lawyers who were practicing in this area of law. But now in the last, I would say 10 to 15 years, a lot of Indian lawyers have gone to foreign law firms and they are doing international arbitration in those foreign law firms. So this is also because of new, master's courses which have come in, and even the general master's courses are offering specialized courses in arbitration. So those provide a good platform for law students to get a job in foreign law firms abroad. That said, it's not easy at all to get a job abroad in a foreign law firm because there's a lot of competition now, especially not just amongst Indians, but also with foreigners also, because there the field is open to everyone. But there is a lot of good quality work being done, and anyone who wants to pursue this area has a lot of scope in the future. In India also, many firms are now having specialized teams in international arbitration. As of now, there are, I would say, 3-4 firms which I know of which have these specialized teams, and I think it's going to grow in future. So, I think that it's going to expand. The number of lawyers doing arbitration is going to expand in future.
Okay, sir. So, sir, can one exclusively start practicing in arbitration, or one should also practice in the courts to get extra edge?
In India, if you are doing domestic arbitration, then I would say that you cannot practice exclusively arbitration, at least as a fresher. Till let's say for 10-15 years at least, till the time you have a name, you should do domestic litigation work as well. Because if you do only arbitration as a fresher, then I think that, in my opinion at least, the worldview is going to be very restricted. And you learn much more when you do court litigation also. But if someone wants to do only international arbitration, then, as I said, now there are 3-4 law firms who have teams doing only that. And those people are doing only international arbitration. So in such situations, it has become, let's say, common for those people to do only international arbitration and no court litigation in India. So there are those kind of people, but my suggestion would be to stay away from that for the first 3-4 years at least, and to do court litigation as well, because it adds to your skills as a lawyer. Thank you for